So let me start by asking you about the New York Times op-ed that you wrote. And you described a war that the president was waging on the federal judiciary, an assault on the rule of law, and described it as a constitutional crisis for the country. What were you saying? What did you see at this moment that we're in?
Mike, the President of the United States has declared war on the federal judiciary, on the rule of law, and on the nation's legal profession. America is in a crisis. America is also in a constitutional crisis. The constitutional role for the President of the United States is to faithfully execute the laws including the Constitution and the statutory laws of the United States enacted by the Congress. Barely 2 months into the President's second term, he has already issued, I think, over 100 executive orders. An executive order is not uncommon, but 100 or more executive orders is extraordinary and unprecedented in all of American history. Now, the idea behind an executive order is that the president is directing the executive branch to do things. That's within his right and prerogative to do. That's not what this president is doing. Essentially, every one of the president's executive orders to date is illegal or unlawful. And most of the executive orders are unconstitutional. That is, on their face, they are violative of multiple provisions of the Constitution of the United States. And then the remainder of them that are not in violation of the Constitution, direct violation of the Constitution, are in violation of existing statutory law of the United States. Now, the federal courts are the last resort at this point for Americans and for America. Our Constitution, one of the geniuses of the Constitution is the separation of powers among the executive branch, the legislative branch, and the federal judiciary. Thus, the so-called checks and balances of that constitutional system of government. Each of the three branches of government has prescribed roles to play in the constitutional order. And the role of the president is to execute the laws, faithfully execute the laws. The role of the legislature, of course, is to legislate or to pass laws that are then signed into law by the president. The role of the federal judiciary is not a political role at all. In fact, it's by design the very opposite of a political role. The role of the federal judiciary is to, as John Marshall, Chief Justice John Marshall, famously said over 250 years ago, it's the responsibility of the federal judiciary to say what the law is. And that's both as to constitutional law and also as to statutory law. The role of the federal judiciary is to interpret the laws of the United States and apply them, if you will, where necessary, to the president and the Congress. So the judiciary, not infrequently, holds laws passed by Congress and approved by the president, declares them unconstitutional as incompatible with the Constitution itself. Almost all of the executive orders that President Trump has issued to date in his first 2 months are encroaching or intruding upon the other two branches of government, both Congress and the federal judiciary. So, for instance, these nefarious executive orders that the president had issued against the nation's law firms are violative of, each of them is violative of many provisions of the Constitution, not just the First Amendment, but the Fifth Amendment's due process clause and the Sixth Amendment's right to counsel. But all these executive orders in particular also intrude upon and attempt to usurp the role of the federal judiciary in this way. The president, with each one of these executive orders, has acted as prosecutor and judge and meted out punishment for the offenses that he alone has determined that these firms have committed. The judiciary will never surrender its constitutional privilege to say what the law is. President Donald Trump can try as long as he wants to and in every way he wants to, but he's going to have to understand at the end of the day that for the federal judiciary to yield to him would literally be to surrender its constitutional role to Donald Trump. That's simply never going to happen.
One place that we're thinking about starting is when the President of the United States goes to the Department of Justice to give a speech, a department where he had been prosecuted. He talks about a feeling that the Justice Department had been weaponized against him. And people have told us it sort of sent a signal that there was a new sheriff in town, that the Justice Department now was going to report to him. What do you see in a moment like that, in a move like that?
The president's political rally, and that's what it was, at the Department of Justice was reprehensible, and of course it was unprecedented in all of American history. Presidents only infrequently go to the Department of Justice at all, and for good reason. Every president until this president has respected not the independence of the Department of Justice from the White House, but has respected the need for separation of the White House from the Department of Justice. The Department of Justice, headed by the Attorney General of the United States, is the chief law enforcement entity in the United States. For so many reasons that we shouldn't even need to recount, there's every reason in the world under our constitutional order for the President of the United States to keep his distance from the Department of Justice. When no president has ever not kept his distance, but we're seeing today what happens when a president does not, and instead, in the person of the president himself, instructs the Department of Justice as to what it must do during his administration. So the President of the United States of America went to the Department of Justice at the beginning of his administration to tell the Department of Justice and the American people that he was going to exact revenge, that he was going to get retribution against those who he views as his political enemies, by name even. And of course, that's exactly what he's done since he left the Department of Justice that day in issuing many of these executive orders. These executive orders, with respect to the law firms, not only name and call out individual law firms in America, but they actually call out by name the clients of those law firms, who the President of the United States regards as his enemies. That's one of the many things that renders these executive orders palpably unconstitutional. So the President of the United States said at the Department of Justice that he was going to end the weaponization of government. What he meant, we all know, was he was going to end what he mistakenly believes was the weaponization of the federal government against him personally. As we all know, the United States of America prosecuted this president for what it viewed as perhaps the gravest constitutional crimes that an incumbent president couldn't commit in attempting to overturn the 2020 election. The United States of America also prosecuted Donald Trump for purloining classified documents from the White House, securing them at Mar-a-Lago, refusing to surrender them to the National Archives where they belonged, and even claiming and obstructing, by the way, the FBI's investigation into the whereabouts of those documents. Of course, the president claimed that he had eventually claimed that he had declassified those documents in his own mind. This is all preposterous. Preposterous. It would be laughable if it were not so serious, and if it were not the conduct of the President of the United States. The federal government has never been weaponized against anyone, least of all Donald Trump. Now, today, Donald Trump is weaponizing the federal government for the first time in American history against his personal enemies.
When we talked to Norm Eisen, who was a lawyer who President Trump sees as an enemy, and in that Justice Department speech, he calls him scum and says he's vicious and has been violent. When you hear that language, you talked about the executive orders, but when you hear that language used by a president of the United States in the Justice Department, with the Attorney General there, with the Director of the FBI there, in a building that you had worked in, what is your reaction to that?
Norm Eisen is one of the finest lawyers in America. Donald Trump criticized Norm Eisen simply because Norm Eisen has been arguing against the constitutionality of many of Donald Trump's actions, including his effort to overturn the 2020 presidential election, for years now. That's the only reason. Just as that was the only reason that Donald Trump has singled out the particular firms that he has for retribution, and the particular lawyers that he singled out by name for retribution, like Andrew Weissman, who was one of Bob Mueller's deputies, and others, individual lawyers. But what did I feel even after all that we've seen from the president over the past 8 years? And maybe this is my fault. I was shocked beyond words. And to watch him stand in the Great Hall of the Department of Justice, a sacred place in America, and claim that the federal government and law enforcement in particular had been politicized and weaponized against him, and that now he was going to get even by politicizing and weaponizing the Department of Justice and the FBI against his political enemies, was a travesty in all of American history.
You talked about the executive orders, and they start on the very first day. He goes to the Capital One Arena and signs them, begins signing them in front of a crowd, and goes to the White House. And as you say, it's more executive orders than other presidents, although all presidents sign executive orders on their first day. Some people have told us...
No president in American history has ever signed one single executive order like the 100+ executive orders that this president has signed. No president. It would never have occurred to any American president in history to issue these executive orders, because every president before now has taken his oath of office seriously to faithfully execute the laws.
Do you think it's part of an intentional strategy to stress the rule of law, to stress the constitutional separation of powers? When you look at what he's doing on that first day, what do you see as far as their strategy?
Well, of course, no one would dispute that it's intentional. No one would dispute its purpose, which is to attack the federal judiciary and the rule of law. And that's with the earlier executive orders. When you add the later executive orders targeting individual law firms in America, then it's crystal clear, frankly, that the President of the United States of America has declared war on the federal judiciary, an equal and coordinate branch of the federal government, the rule of law, and the nation's legal profession. There's just no dispute. Donald Trump wouldn't even dispute that, I assume, and if he did, it would be a meaningless disputation because his words would betray the opposite of that disputation.
It was the same day that he issued the blanket pardon to people convicted for crimes related to January 6th. Did that send a message to you that he had promised to do it during the campaign, but it was more extensive, I think, than a lot of people expected?
It sent a message to the world, literally to the world, but also to America, that he believes, again, profoundly mistakenly, that he was victimized by the federal government in the past 4 years. Victimized by America itself is what he doesn't say. But that's in fact what he is saying. So what was it, a surprise that he pardoned the January 6th? No, of course not. It was just a message to the world that Donald Trump was going to conduct his presidency in revenge and in retaliation against his world of political enemies, Republicans and Democrats alike. And that's exactly what he's doing right now in these first 60 days. You know, I think I said in the New York Times piece that if he continues down this course, he will essentially be a lame duck president before his political honeymoon is even over in the first 100 days. Or at least that's what should be the case.
There are those among the president's supporters who say that what the president is doing is pushing back against sort of wrongly decided precedent and laws that built up after Watergate, and the idea of a unitary executive and reinvigorating the executive branch as part of the president's project. What do you make of that argument that there's this legal theory, the unitary executive that's there, that's underlying some of what he's doing?
Well, we must be very precise here. But the first thing to be said is that argument by the president's supporters is fallacious. It is anti-constitutional for this reason. Well, let's go back to basics. Every person in the United States of America is obligated to abide by and follow the law, including the President of the United States. Indeed, especially including the President of the United States. Now, this president doesn't believe that the laws extend to him. And frankly, the Supreme Court gave him reason to believe that the laws don't apply to him when in Trump against the United States last year, the Supreme Court gave this president, essentially absolute immunity from criminal prosecution for any act that he takes arguably in pursuance of his official duties as president. That is, for all intents and purposes, absolute immunity from prosecution. Now, that's not to say, and this president certainly does not understand this, that this is not to say that the Supreme Court said that the president could do what he's doing now. What he's doing now is unlawful, if not unconstitutional in most instances, under the existing laws and constitutional decisions of the Supreme Court. So now let's turn to the so-called unitary executive theory. That theory essentially says that the President of the United States, as the chief executive officer under the Constitution, has complete control over the executive branch of the government and all executive agencies and departments within the executive branch. That theory has been out there, and it has a firm constitutional basis for 50 years. The Supreme Court decided a case styled Humphrey's Executor in 1935, so almost 100 years ago, which gave birth to the unitary executive theory. In Humphrey's Executor, the Supreme Court said that the President of the United States could not remove the head of a so-called independent agency or department except for cause. And for the past 90 years, scholars and thinkers about the Constitution have debated the unitary executive theory. And today it is still in my view, a sound constitutional theory. But I would say this. This is the last president in the world for whom the Supreme Court should approve the unitary executive theory. The Supreme Court now knows exactly what Donald Trump will do if the court were to hold that he does have exclusive power over all of the executive branch, including what had been understood to be the independent organizations and entities of the executive branch, including, for instance, the Federal Reserve.
You said that Trump versus United States did not grant the president the authority to do many of the things that he is doing. It has been cited by some of his supporters, by Mark Pauletta, who have looked at some of the language inside that and see vast executive power. And you were critical of that decision to grant immunity. How much responsibility do you think that court bears, that case bears, for the moment that we're in?
I thought Trump against the United States was literally the worst Supreme Court decision in history. I analogized it on day one to the court's insidious decisions in Dred Scott and Korematsu. And then I think the next day I said something to the effect that it's even a worse decision than those because it corrupted what's known as the structural Constitution, by which I mean it corrupted the separation of powers. To your question, Trump versus United States gave the president essentially absolute immunity only from prosecution. So that decision of the Supreme Court really has nothing to do with what the president is doing today through these 100+ executive orders. What the president is doing with these 100+ executive orders, in almost all of them, is exceeding his legal authority, either under the Constitution or under the laws of the United States. That's not to say that excess, as egregious as it is, and as incompatible as it is with the Constitution and the rule of law, it's not to say that would constitute criminal conduct. It would not. That leads me then to this answer to your question, which is there is nothing incompatible between Trump versus United States and that absolute immunity from criminal prosecution and the president's pursuit of, for instance, of the unitary executive theory of government, or of his pursuit of even of power for power's sake. Those activities reflected in those executive orders, the 100+, are violative of the Constitution and violative of the laws of the United States for the most part, but they do not constitute criminal activity by the president.
You served in the Office of Legal Counsel, which renders decisions about the law, the constitutionality of executive orders, and other things. The Attorney General issues a memo early on that makes clear that the word of the president's interpretation of the law, her interpretation of the law, should be binding on the Justice Department. And from people we've talked to, the Office of Legal Counsel hasn't been involved in some of these executive orders that you've been talking about. What do you make of the direction coming from the Attorney General on interpretation of the law, on changes inside the Justice Department relating to the Office of Legal Counsel?
Well, there's never been an occasion in American history for almost 250 years for a president of the United States even to make such a statement. Now, the statement that he made, that only he and the Attorney General can interpret the law insofar as he meant for the executive branch, is true and unobjectionable. What it appears now the president meant is that he and the Attorney General alone can determine what the law is, period, and not the judiciary. We know that because of late, he and Elon Musk have been calling for the impeachment of federal judges who rule against Donald Trump and his administration. And in fact, that prompted a rebuke from the Chief Justice of the United States just last week, when Chief Justice Roberts, very publicly and in very much a direct rebuke of the President of the United States, reminded the President that impeachment is not the process, the constitutional process for disagreeing with federal court rulings. The Chief Justice and the Supreme Court, we all know at least this. They see what's coming. Who wouldn't? But that rebuke assured America that the Supreme Court understands what Donald Trump is doing and that it will have none of it. One of the most chilling things I saw in the past week was that the federal judiciary has set up a panel to deal with the threats on the lives of the federal judges who rule against Donald Trump. And of course, in the same week that it did that, Justice Amy Coney Barrett's sister, I believe, had received a bomb threat in Charleston, South Carolina. But just think, the federal judiciary is impaneling a group of its members to discuss the threats, the physical threats on the lives of federal judges who rule against this president. If I'm remembering correctly, Elon Musk, in his detestable tweet, urged that Congress impeach every federal judge who rules against Donald Trump. Just this morning, I woke up to the story that Senator Grassley is introducing legislation to eliminate nationwide injunctions. In his statement, he said that this is to prevent the politicization of the federal courts. But he also went on at length to say that the federal courts are ruling against Donald Trump's agenda, and that he believed that had to stop. And so he's proposed legislation to prevent the nationwide injunctions that have been issued in a number of these executive orders. A nationwide injunction just means what the term suggests, which is a single federal district judge can enjoin the administration nationwide from enforcing, if you will, an executive order. This too, like the unitary executive theory, has been a topic of scholarly debate and discussion for years. And there's no question that it would be legitimate were Congress to eliminate the capacity for the lower federal courts to issue nationwide injunctions. But just like with the unitary executive theory, it is clear to the world, because the president and now Senator Grassley have made clear to the world, that the only reason that they're pursuing these limitations on the federal courts is because the federal courts have ruled against the president and his administration. So just like with respect to the unitary executive theory, in my view, this would be the worst moment possible to eliminate the nationwide injunction, because today, in this moment, because it's the president that is politicizing the courts and the law, it's not the courts that are politicizing the courts and the law, it's the President of the United States. So to enact a ban on nationwide injunctions right now would unquestionably be to, one, accept the premise of that legislation, which is that the courts are political, one, but two, it would be, in fact, to politicize the courts in the image of the President of the United States. But I want to make those 2 points very clearly as to the unitary executive, which underlay much of what the president's doing. underlays it somewhere. The president probably has no earthly idea. But his thinking lawyers, they know what they know about this. But the independent, unitary executive and the nationwide injunctions have been legitimate questions for the past decades. Right now, if the court were to adopt the unitary executive theory, and if Congress were to eliminate the nationwide injunctions, that would, in this moment, serve to politicize the federal judiciary. And by the way, of course, those two efforts, if you will, are part of the larger effort to delegitimize the federal courts and to undercut or undermine the rule of law in America. They would not have been thought that before today, but there's no question in the world that that's the way we must think of them today in light of what the President of the United States is doing. America's been the envy of the world and the beacon of freedom to the world for almost 250 years because of its democracy and because of its rule of law. Americans fought the Revolutionary War against Great Britain and its monarchy, the king, in order to create a constitutional system of self-governance under the rule of law. And that system of government, which we have happily lived under for almost 250 years, and it's been the envy of the world for almost 250 years, is now under withering assault by the President of the United States.
Early in the administration, there's a number of resignations around a deal to drop charges against the mayor of New York, Eric Adams. The acting U.S. attorney for the Southern District ends up resigning or being pushed out, really. A number of other lawyers at the top of the Justice Department, amid her allegation that there was sort of a political quid pro quo and that she couldn't ethically make an argument to the court to drop or to suspend those charges. What did that moment tell you about where we were going?
Well, too much had occurred before that for that to tell me much additional. But I would hope that no serious lawyer would put up with any of this for one day. I mean, the President of the United States is literally directing the hand of even individual prosecutors at the Department of Justice. The Attorney General of the United States is the chief law enforcement officer of the United States. It's her profound obligation not to permit these executive orders, not to permit these attacks on the rule of law, the federal judiciary, and the nation's legal profession. But of course, that's the opposite of what she's pledged to Donald Trump that she will do. This is all, it doesn't get any more serious than this in the United States of America.
In the American constitutional order, American democracy, how unusual is it to have a figure like Elon Musk, an office like Doge, that does something like shut down USAID, congressionally created agency, congressionally funded agency?
Well, there's two different things at work there. First off, Elon Musk is unknown to the Constitution and laws of the United States. Now, I believe his appointment or whatever it was unconstitutional. Appointment by Donald Trump was unconstitutional. Based on 250 years of Supreme Court precedent, someone who occupies the position with the responsibilities that Elon Musk has been given is an officer of the United States. To be an officer of the United States, one must be nominated by the president and confirmed by the Senate. That's what all cabinet officers are required to do. Obviously, that's what federal judges are required of federal judges. But I gather that, the president is calling Elon Musk a special government employee. That is a recognized classification of employee, but no special government employee has ever been anything approaching an officer of the United States in the way that Elon Musk, without any question, is. I think I just read yesterday that Mr. Musk intends on leaving in May as his time as special government employee expires. At least at that point, if not long before, the Americans will understand the constitutional affront that Mr. Musk has represented to America.
And to shut down a government agency, to send everybody home.
Yes. That was the second aspect of it. Again, the President of the United States doesn't have any power or authority whatsoever to close a department or agency of the federal government. Departments and agencies of the federal government are creatures of legislation. Only Congress has the power to create or disestablish an agency or department of the government. Now, today's Republican Congress, of course, is either wildly enthusiastic about everything that the president's doing, or famously supine. It doesn't matter which. The point is that the Republican Congress is not going to utter a single word against anything that the president's doing. But of course, heretofore, our politicians, they cared about the Constitution and laws of the United States. But that's no longer true. So the Congress of the United States is supposed to be a check on this presidency, but just as certainly it hasn't been, and I doubt it will be for the duration of President Trump's tenure in office. But so the short answer to your question is that the president has, not only does he not have any authority to close down these departments and agencies, in doing so, he's usurping the role of the Congress of the United States in the same way that he's trying to usurp the role of the federal judiciary.
How important is that fact that Congress is not pushing back? As I understand it, part of the framework of the separation of powers was an idea that they would guard their prerogatives, and there would be institutional reasons why Congress might react in a moment like this, and yet it's not happening. Is it a flaw in our system? Is it part of what you described as a constitutional crisis, the way that Congress is reacting?
It's everything. The fact that the Congress of the United States is silent in the midst of this crisis and constitutional crisis is unforgivable. It's the polar opposite of what our founding fathers and the drafters of our Constitution intended. The system created under the Constitution was one of separated powers, under which each branch serves as a check and balance on the other branches. Right now in America, one could not say that we have the separation of powers that was envisioned by our founders and written into the Constitution of the United States.
How much pressure does that put on the third branch of government when the Congress is standing by, when the president is shutting down agencies, sending people home, as you say, hundreds of things going on at the same time? How much pressure does it put on the judiciary to retain the constitutional order? How much stress is it under in this moment?
Extraordinary, unprecedented pressure and stress, never known by the federal judiciary and never to be known by the federal judiciary, according to our founders and the framers of our Constitution. The President of the United States is at war with the federal judiciary, with America's independent federal judiciary. And he's made no bones about that. It remains to be seen whether he will win that war against the federal judiciary or whether he will lose that war against the federal judiciary. It's too soon to say, because his full frontal assault on the judiciary just began a couple of weeks ago. And the individual judges have had the occasion to respond, but not yet the entire federal judiciary, save the Chief Justice's frankly mild rebuke of the president, reminding him of the separation of powers and the fact that impeachment of federal judges is not the recourse for disagreeing with their opinions. That's a very mild rebuke. And of course, the very next day, the president returned to calling for impeachment of federal judges. This president, he really doesn't care what the Supreme Court says, and of course he doesn't care what any lower, federal court says. So the judiciary should be busy about zealously guarding its constitutional independence from this president. Only the judiciary can do that. But I think that Americans have a question at this point of whether the federal judiciary and the Supreme Court are up to that task. God save us if the federal judiciary does not stand up for itself in this moment of crisis.
You said the American public. What about yourself? What's your confidence in the judiciary in this moment?
Well, I am of the federal judiciary. Serving as a United States Court of Appeals judge was the greatest honor of my life. I believe in the federal judiciary more than I believe in anything else in the world. But I'm watching these vicious frontal attacks, unapologetic, by the President of the United States, and I'm just not clear in my own mind that even the federal judiciary can withstand this kind of attack by the President of the United States of America.
You talked about your judgment that the executive orders about the lawyers was not constitutional, was not legal. Do you see that as part of what we're talking about of an assault on the third branch, on the ability of people to jealously advocate for different sides on a case? Is that what you think how do you see what the president is doing in issuing executive orders like that?
Oh, there's no question. The federal courts and the legal profession are the only obstacles to this president's insatiable appetite for power for its own sake, not power to use in service of the nation and the American people, just for himself. These attacks on the nation's law firms and legal profession are, by their terms, intended to, first, to put the individual firms out of business, but then larger, to send a message to the nation's 1.2 million lawyers that they better never take again a case representing a client against Donald Trump and his administration. These are some of the first steps that are taken in pursuit of tyranny. That is, to attack and undermine the judicial system and whatever country's legal profession.
But Paul Weiss makes a deal with the president. They have internal letter, as we understand it, that says we think that this is not legal, that we would win if we went to court, but that the clients see a signal from the president, and whether the executive order is legal or not, this was a threat to the firm. What do you make of the position that the big law firms are in, and the decision of some of them to settle?
Well, Paul Weiss sold out itself, once a great law firm, sold out its associates, sold out its former partners, and sold out the entire legal profession in, quote, cutting a deal with the President of the United States. Like the other executive orders targeting law firms, the executive order against Paul Weiss was extortion, pure and simple, by the President of the United States. And Paul Weiss enthusiastically agreed to that extortion. Rightfully and thankfully, the firm has been roundly criticized nationally, not just by lawyers, but by everyone else. The American people understand what's going on here. They understand that, what Donald Trump's trying to do with these executive orders against the legal profession. And if they don't, I would just tell them this. If you, a client, come into disfavor with Donald Trump, you will not be able to get a lawyer to represent you, whether that's before the Social Security Administration, Health and Human Services, the Labor Department, the Defense Department. If Donald Trump doesn't like you or what you stand for, you will not be able to get a lawyer to represent your cause before the federal government. Now, Skadden Arps, as I understand it, has recently also agreed to the extortion. But two other firms just this past week said no. They will stand firm against this extortion and they will stand firm on behalf of the nation and also the legal profession. And that began with Jenner and Block, a great Chicago-based multinational global firm, followed on by, the same day by Wilmer Hale, another great global law firm. Both of those firms, rather than negotiate a deal. What does that even mean? Negotiate a deal? These are supposed to be professional lawyers. That is, they are part of the noble profession of law. Lawyers are known for representing clients against the world. That's their highest obligation. And yet, Paul Weiss and Skadden Arps sold out themselves in the profession. But back to Jenner and Block and Wilmer Hale. Of course, they had the, quote, benefit of seeing Paul Weiss and Skadden Arps and their unforgivable conduct. And they both have now sued essentially every entity of government, including the United States Department of Justice. And I think it was the very day that they sued, two separate district judges in the District of Columbia and joined the executive orders. There's not a court in the land, especially the Supreme Court, who will ever uphold those executive orders targeting the law firms and individual lawyers. They're unconstitutional on their face. They are violative of multiple provisions of the Constitution. It would be impossible under law for a court, any court, to uphold those executive orders. If Donald Trump, maybe I should put it this way. Perhaps the best thing that could happen for America is for Donald Trump to insist that the Supreme Court of the United States decide one of those executive orders targeting the nation's law firms and the nation's $1.2 million lawyers. Lawyers are the officers of the court. Those executive orders, they may only be targeting lawyers and law firms, but those executive orders are a direct attack on the federal courts of the United States of America, including, especially, the Supreme Court of the United States.
And other companies that are not in the legal profession are paying attention to this. I saw car companies that had been threatened saying they saw what happened to the law firms. What does it do to our, because we've been talking about inside government, but what does it do to our American constitutional order if these different players in civil society and private industry and universities have a fear of what could happen if they push back against the president?
Well, the first thing to do is focus on the fear and think about that. Americans are trembling in fear of the President of the United States for the first time in all of American history. That's really the story and the only story. Then the second point to be made is every single aspect of those executive orders, and there were many aspects, is demonstrably unconstitutional on its face, because every aspect, by the president's own words, was done in retaliation and retribution for the clients that these law firms have had in the past, and or lawyers who were employed at these law firms in the past. These orders, bar these law firms and these lawyers from entering federal buildings. They bar them from entering the courts. They bar them from entering the Supreme Court of the United States, because the courts and the Supreme Court are, of course, federal buildings. They essentially prevent clients that the president doesn't like from seeking representation from those law firms. And they make crystal clear that if the law firms accept representation of clients that the president doesn't like, that the entire federal government will punish those law firms and, of course, those clients. It's hard even for me to utter those words. But that's what has happened in the United States of America today.
What do you make of the moment when the president invokes the Alien Enemies Act? There's a flight of Venezuelans that seems to be rushed off to El Salvador, and in the middle of that, there's a restraining order issued. What do you make of that incident in that moment?
I wrote about that incident for the New York Times this past week. The hearings are being held before the chief judge of the federal district court in the District of Columbia, Judge Boasberg. Judge Boasberg is as fine a jurist who's ever sat on the federal bench. He's actually served as the Foreign Intelligence Surveillance Court, which itself is a high honor. There's no one other than Donald Trump who would call him a radical liberal lunatic. No one other than Donald Trump and Elon Musk. All that he is trying to do is determine whether the Alien Enemies Act applies to these this allegedly Venezuelan gang. That's all. Now, the point to be made is this. That's what he's trying to do, is determine what the law is. That's what judges do. That's the constitutional role for the federal judiciary. Just determine what the law is. Or in Chief Justice John Marshall's famous words, say what the law is. That's why we have an independent judiciary. Now, needless to say, not an American president in all of history has ever called for the impeachment of a federal judge because he or she ruled against them. This is unequivocally, indisputably, an attack by the president on the independence of the federal judiciary, pure and simple. It's not even debatable that that's what he's doing. But one of the most remarkable things about these hearings before Judge Boasberg is the arguments that have been made by Donald Trump's Department of Justice. To the argument, no such argument has ever been made in a court of the United States by the Department of Justice. It's embarrassing to the lawyers who are making these arguments. It's embarrassing to the Attorney General of the United States. And it's embarrassing to the President of the United States. No one, no lawyer, I started to say no serious lawyer, but no lawyer should ever be making arguments like that. And to say that their arguments is giving them too much. Before Judge Boasberg, the Department of Justice has basically attacked Judge Boasberg personally and as a federal judge in not only the arguments that have been held, but in the briefing. And Judge Boasberg, to his great credit, refuses to have any of it. And he's called the lawyers out, as did Judge Howell, by the way, in the law firm cases, and other judges have begun to also. This is what Donald Trump calls the politicization of the judiciary and the weaponization of the federal judiciary against him. But Americans are smarter than that. They understand, rather, that this is the politicization and weaponization of the federal judiciary against Donald Trump's enemies. So I wish we had time just to read some of the language from the briefs and some of the things that have been said by the Department of Justice, the United States Department of Justice, to the federal courts in the past 2 months. If the federal judiciary does not put a stop to this right now, then there's no hope for America.
There's a dispute about the Alien Enemies Act, about whether they need to disclose in response to the court order, and there's also push for him to recuse himself. Which of the arguments are the ones that are a big red flag for you?
Well, I'm not going to, intellectualize any of their arguments. They're unacceptable in a court of law. They are, quote, arguments that ought never be made by lawyers representing the United States of America from the Department of Justice. Now, the two that you mentioned, two aspects, they really go to larger questions. In particular, the Department of Justice is wrongly arguing that the federal courts are usurping the role of the President of the United States. Wrongly. That's what they're saying in open court. Well, the judges of America, they know what's going on. The second aspect you mentioned was the recusal. That goes hand in hand with the impeachment. But here you're talking about mid-hearing. Judge Boasberg had just preliminarily and only tentatively, preliminarily but only temporarily, ruled against the Department of Justice and Donald Trump. And what did the Attorney General of the United States do? Called for Judge Boasberg's removal from the case and for his impeachment. Impeachment of a federal judge who had only preliminarily and temporarily ruled against them. Now, I will comment just broadly on the merits, because other judges have at this point. To say this, the Alien Enemies Act was enacted for times of war. And it's only been invoked 3 times, as if I'm correct, since its enactment. Each of those times was in a time of war. Whatever else, we are not in a war. And that was that's been the suggestion of the federal courts who have begun to look at this issue. I don't know enough about it to come to a conclusion, but I really don't have any doubt in the world that the Alien Enemies Act is not invocable by the President of the United States today.
When I hear you talk about this, about the arguments the lawyers are making about the executive order that the president has made, I get a sense that you're saying these are not good faith arguments, legal arguments, which we normally would expect in court. We would have a combat of different people interpret things different ways. Is that what you're saying? Is that why it seems to upset you?
Well, that's one reason, but let's be clear. These are not good faith arguments at all. But neither does the Department of Justice present them as good faith arguments. You don't present a good faith argument by telling the federal court that they don't know what they're doing, that the President of the United States does know what he's doing, and that their job is not to interpret the law. Rather, it's the President's job to interpret the law. That's the very definition of bad faith. And again, all lawyers are officers of the court, but the Department of Justice's lawyers are the highest officers of the court. They have the highest obligation in the land to present the arguments to a federal court in good faith as representatives of the United States of America, not as representatives of the President's Department of Justice, as representatives of the United States of America before the federal courts of the nation. There is no higher obligation of a lawyer. And yet, we're seeing what we're seeing from the Department of Justice lawyers.
And when the White House drafts these executive orders, which you could pick any of them, but which don't necessarily cite legislative reasoning or are explicit that a law firm is being targeted because the president disfavors it, where there's not even much of an attempt at a fig leaf of a legal analysis. What does that tell you, and how concerning is that there isn't even an attempt to engage on that level?
Well, there's not a lawyer, including the Attorney General of the United States most notably, or the White House counsel secondarily, who is both advising the president on the Constitution and the law and being heard. But as to the Attorney General of the United States, from her public comments, I don't have any question that the Attorney General of the United States is approving these executive orders. And that should tell Americans all they need to know about the Attorney General of the United States. I once headed, it was one of the great privileges of my life to head the Office of Legal Counsel at the Department of Justice. Former heads of that department include Justice Antonin Scalia, Chief Justice Rehnquist, other great American lawyers like Ted Olson, Chuck Cooper. None of those people, none of them would have ever signed off on these executive orders. Not one of them. But these were men of great stature, great principle, and profound professionalism. I don't know if this is true or not, but I've read that the President and the Attorney General are not even consulting the Office of Legal Counsel at this point. And if they're not, it's for all good reason. No lawyer who works in that office would ever approve these executive orders. I don't know even who the White House counsel is, but the White House counsel, well, let's put it this way, if the White House counsel isn't approving them, then there is no lawyer approved. No official lawyer who's approving them. but I have to believe that he or she, whoever it is reviewing these and advising the president that they're fully constitutional and lawful, which also should tell the American people a great deal about the White House counsel.
We've talked about the rhetorical threat to the judiciary, the threat of impeachment. There's also, though the president has not said that he wouldn't follow a judicial order, there's talk among his supporters. His orders has said, I don't care what a judge thinks. There's a lot of discussion of would it reach a point, especially on a politically powerful issue like immigration, where the president or the White House might decide to disregard a court order. Just that talk that is out there right now. What effect does that have? Does that have an effect on judges who are deciding these cases? What does it tell you that conversation has started?
Well, America is in a constitutional crisis today, and has been for weeks, if not the past couple of months, because of the president's war on the federal judiciary and the rule of law. So we're in a constitutional crisis. Now, every scholar of the Constitution and every thinker about the Constitution would say that if there comes a time when the president defies an order of the court, then we are, without any question, in a constitutional crisis. But my point is, he's been defying Judge Boasberg's order. So if you're looking for a defiance of a court and a court's order, you have it. If that's not sufficient, which it is, then you have to wait until he defies a Supreme Court order. As your question, intimated, the president, his vice president, they've been provoking the talk that the president at least ought to defy a federal court orders where, in their view, the federal court has overstepped its bounds. The president has given the country every reason to believe that he will defy a Supreme Court order. And if and when he does, looking across the executive orders to date, it would be his in his case against Judge Boasberg over the Enemy Alien Act. The president has made clear through the Department of Justice and even from his own mouth that he believes that he has the what he calls, or his lawyers call, the inherent power to deport these alleged gang members, who, by the way, it appears, many of whom are not even gang members. But he has the inherent power under Article 2 to deport these people in the interest of national security. Now, he does not have any such power at all. when a president is exercising truly exercising his powers as commander-in-chief to protect the nation's security, his powers are at their zenith. But whereas here the president is merely asserting that he has such national security power, but in fact does not, then his asserted national security powers are at their nadir, which is legalese for saying that even if the Alien Enemies Act applies, or if the Supreme Court were to hold it applies, these people would have been entitled to some measure of due process. If the court were to hold that, then today at least that would seem to be the kind of order that this president would defy.
Justice Roberts and the rest of the court must know that. I mean, he issued a statement. He must be aware of the political moment that he's in, of the fragility of this situation. And I wonder what you make of that and whether these pressures can have some effect on the court. I mean, the decision that started all, Mulberry, is sometimes seen as a case of asserting power, but without going so far as to break everything. I mean, do these pressures on the court, will they be cognizant of them and try to find a way to avoid direct confrontation, or is that not possible here? What do you make of that?
The court is fully cognizant, and this is a signal moment for the courts and for the Supreme Court in all of American history. But the court will never surrender its constitutional role to interpret the Constitution and the laws of the United States, especially not to this president. Never. It will never happen.
In your op-ed in the New York Times, when you warned about tyranny, what did you mean? What does that word mean?
Well, I think that, from a lay perspective, I'm not an expert in the uses of those descriptions of governments, and I don't profess to be. What I meant was a tyrannical federal government led by a tyrannical president. That is, a president who has no interest in faithfully executing the laws, but rather only in seeking the laws that he wants and wants to abide by and follow. In various places, that's described also as absolute power. And of course, this is the polar opposite of what Americans fought for in the Revolutionary War. It's the polar opposite of what our founders created once they had gained their independence from the British Crown. And of course, it's also the polar opposite of what the framers of the Constitution embodied for the government, the federal government, in the Constitution of the United States. It's the very opposite. Very opposite. And for almost 250 years, no one has ever questioned any of this at all, let alone a president of the United States.
You go back in the article and specifically talk about it going back to the Declaration of Independence and an idea at the beginning of the country that is it a rule of the law or rule of man? I mean, explain what that means. Why does it go back that far?
Well, I don't expect most Americans to know much about the Constitution, much about the law. But every American knows, every single American knows that in this country we have what is known as, government by laws, not by men and women. It would trivialize it to call that Civics 101. But what it is the most basic, fundamental, foundational principle of this country and of our Constitution. How is it manifested every day to every single American? Every single American enthusiastically accepts that they must live in accordance with the laws. That is the rule of law. That's why every American needs to understand as to what's going on right now. If the President of the United States doesn't like you for some reason, or what you stand for, or a group that you're affiliated with, if he doesn't like you, then he will not apply the law, fairly to you. Just like he hasn't applied the law fairly in these executive orders to law firms and even to individual lawyers. And then that causes me to wrap back around to the Enemy Aliens Act that's before Judge Boasberg. The other thing that every American knows, and this they know all that they need to know about, is due process. There is nothing more well known to the American public writ large than due process. They may not even know it as due process, but they know that whenever the government comes against them, whether it be in a criminal proceeding, a civil proceeding that where the government intends to take away your property, your liberty, that you're entitled to be heard. That's all. That's what due process is. You're entitled to explain to the federal government why what they are about to do to you is wrong. take the Venezuelans who have been deported. All that they are asking for is, a modicum of due process. And some number of them have said that they're not members of the gang at all, and that the tattoos that they wear have nothing to do whatsoever with the gang. And the Trump administration does not want to give those people the opportunity simply to make their case to the federal government that they're not members of the gang at all. That's about as rudimentary and fundamental to America as anything that I can conceive of. As I was speaking, it reminded me that I think it was John Adams who represented British soldiers in the highest calling of the legal profession, in order that even those soldiers against whom America had fought a war for its independence had due process, elemental due process to be heard. That's all that we're talking about. And the President of the United States should always want that for every person who's in this country, whether legally or not, because that's a large part of what's made America the envy of the world for almost 250 years.
You wrote that it was the American people, the Congress, and the courts that would have to respond to this moment. I mean, do I read in that you think the courts themselves are not enough? What did you mean in saying?
I don't think that the courts are enough. This moment calls for the American people to stand and speak and tell this president what they believe in and what they do not believe in. And by that I mean, do they believe in the federal judiciary, the independent judiciary in America? Do they believe in the rule of law? And do they believe in the Constitution of the United States? If the courts alone say that to the American people, that will be insufficient in the long run. This does call for the American people.
It sounds like you have some confidence in how the judiciary will react. How much confidence do you have in how this will all play out?
Today, and for today only, very little confidence.
Why?
Because of what we're seeing. How could anyone have confidence at this moment? This is day to day in America. Literally, day to day. We will not know the answer to this for months to come.
Is there anything you're watching especially carefully? Anything that could be a sign that things are headed in the wrong direction?
My attention these days is riveted on the federal judiciary. Every decision, every word, and also its oral or written statements about this crisis, constitutional crisis, involving the only branch of government that can put an end to this anytime it wishes.
How much concern do you think there is in the judiciary of which you were a part of fear for personal safety, fear for the rule of law in this moment?
I know for a fact that many judges, federal judges, are shaken by all of this, as they should be. But I also know that they are unshaken in their resolve. That's what gives me the confidence that I do have today. But as I said, this story of America in constitutional crisis is being written every single day right now.
And I could have asked you this as the first question, but because the president likes to target, as you say, Judge Boasberg as a radical left lunatic judge, can you tell me about your background and how you came to this and your work in both two of the branches of government?
Well, that we don't have time for that, but it was always a dream of mine from college in the 70s, 1970s, to be a federal judge. And it was a great privilege of mine to have worked at the Supreme Court in an administrative capacity as long ago as 1976, I believe. So scary, but that's almost half a century ago. And then it was the greatest privilege of my life to have been able to serve on the United States Court of Appeals for 15 years. Interesting vignette. Right out of college, I actually had an opportunity to work at the Ford White House. I was a bag carrier, if that. But shortly after I got to the White House, I got a call from the administrative assistant to the Chief Justice, who asked me to come to the Supreme Court to work administratively for the Supreme Court and for the Chief Justice in particular. So when I got that call, I called my dad, and I said, well, what should I do? And he said, son, everything that you've always believed in, every single thing that you've ever believed in, is at the other end of Pennsylvania Avenue. That's the best advice I can give you. And I left the White House to go to the Supreme Court. As I said, it's hard to utter the words, but almost half a century ago. And then on that path to today, I had other great privileges, truly great privileges, to work at the highest levels of the Department of Justice, and and in the White House. So I'm older today than I was yesterday, but these have been wonderful experiences from which to see and think about America, our Constitution, our constitutional form of government, and the rule of law. And that's essentially what I've thought about the most my entire life.
And I gather from our interactions with you that was a reluctance to be in this more sort of public side. I mean, what led you to feel like you needed to speak out, to talk on camera, to write op-eds in this moment?
Well, reluctance would be an understatement. A federal judge, in my view, should never be seen at all in public, and never should say anything, quote publicly, except through his or her judicial opinions. And I could be misremembering, but I think for the entire 15 years that I was on the federal court, I may have only spoken at a judicial conference event once or twice. Certainly never wrote anything. But 20 years later, after I had left the court, January 6th, 2021 came to pass. And then Vice President Pence's outside counsel and a good friend of mine, dear friend of mine, Richard Cullen, called me and asked me to help. And from that day to this day, I've devoted pretty much my entire life to all of the issues that came out of January 6th and that are now presented to the American people in the first 2 months of the president's term. I will say that it's as unexpected as it was. In fact, it's been surreal. This now has become the highest honor of my life, to address all of these issues publicly in front of the American people, whom I believe that I serve at this point. Of course, this is all I'll ever be remembered for now, and I'm fine with that.
It sounds like you feel like it's a calling in the way that you had one to be a judge.
I wouldn't call it a calling, but from January 6th to today, I have felt a profound obligation to speak about the issues that have been confronting our country. A profound personal obligation to speak.